All right, let me read some stuff about due process. Okay. Denial of due process offends some principle of justice. Let's see here. I can't read everything on due process because we'll get in trouble, but I'll try to read what I can. Okay, let's see. It is now settled. Okay, I can read this. It said the United States Supreme Court said that it is now the settled doctrine of this court that the Due Process Clause embodies a system of rights based on moral principles so deeply embedded in the traditions and the feelings of our people as to be deemed fundamental. Due process is that which comports with the deepest notions of what is fair, right, and just. The Supreme Court of Kansas said that due course of law or due process of law or law of the land is law in its regular course of administration through the courts of justice. Who is this? This is the feds. This is a United States Supreme Court case. They said the United States cannot interfere with private rights except for legitimate government purposes. They said the constitutional prohibition prevents states from passing laws impairing the obligation of contracts. The states are prohibited from depriving persons or corporations of property without due process of law. They said that the Fifth Amendment contains restrictions from the Magna Carta. Where did those restrictions come from? They come from the common law of England onto the government. So the common law of England restricts the government. That is the purpose of the common law of England. They said the Fifth Amendment contains restrictions from the Magna Carta. Among them are the provisions that no person shall be deprived of life, liberty, or property without due process of law. These are restrictions upon legislative as well as executive power. What is due process of law is well understood. It is the law in regular course of administration through the courts of justice. They said that the law of the land does not mean at the act of the General Assembly. If it did, then every restriction would be at once abrogated and private property would be at the mercy of the legislator. So they said there's no point in American history, and there's no authorization in American law where they can write things and it can be presumed as taking away your rights before you get to the jury. Does that make sense? It means they can't just write whatever they want and call it law and then take away your rights before. So they can't write things that take away your rights, and then they can't write things and then enforce to take away your rights before you've gotten to the jury. Not a guy in a black robe, the jury. Right? They said these restrictions come from the Magna Carta. The Magna Carta says you can't be diocesed of your freehold or have your life, liberty, or property taken away without the lawful judgment of your peers. The end. And they said that that was the law of the land. And so they said this thing called the law of the land doesn't mean that whatever the legislator may deem available to take away. They said this has nothing to do. The legislator has no power to take away rights. So if they can magically write that, I don't want to get in too much trouble, but they can't magically assume that things can just be taken out of paychecks and bank accounts froze and all these other things. especially if it has not gone to the jury. They said the guy in the black robe has never been given authorization to take away life, liberty, or property, federal or state. This is the United States Supreme Court talking about the Fifth Amendment. So it doesn't matter what they call you. They call you a United States citizen. It doesn't matter. All the presumptions are void because there's only one group of lawful judges in the 50 states, and that is the jury. So they said law of the land does not mean at the act of a general assembly. They said if it did, that means every restriction upon legislative authority would be abrogated and private property would be at the mercy of the legislator. It said this is the Supreme Court. The United States Supreme Court said no human has been beyond the protection of the Fifth Amendment. How many? None. Whether they were born here, whether they weren't born here, whether they had all their paperwork, whether they didn't have their paperwork, no human under federal or state has been beyond the protection of the Fifth Amendment, which clearly, explicitly states that the common law restricts whatever they write. Does that make sense? They can't presume to take away life, liberty, or property, especially if it has not gone to the lawful judgment of the peers. It's one of these I can't read. Let me see. Here we go. Oh. No, not really. They can't with a fiction. They can disregard it initially under a presumption that we've gave them. So how do they get away with it? Because we've ignorantly participated in having fictions. And we don't know the law no way. Don't nobody know you got the common law of England. The Magna Carta restricts the current government. Don't nobody know that. So how do they get away with it? They get away with it because of our ignorance. But it's never been lawful for them to do it. They do it because we accept it. Like we talked about yesterday. Equity only works on fictions. If we didn't accept fictions, they wouldn't have no authority to begin with. But because we do accept fictions, they get to disregard and ignore the law. So this is a dual issue. They're not allowed to do it, and we're also not supposed to be letting them do it. All right, I don't want that. Let's see here. Nope, can't read that one. Here we go. I can read these. The United States Supreme Court said that a statute creating a presumption which operates to deny fair opportunity to rebut it violates the Due Process Clause. They say it again. An irrebuttable presumption has long been disfavored under the Due Process Clause of the Fifth Amendment. And they said they're condemning or correcting Connecticut for creating a statute mandating an irrebuttable presumption. What's an irrebuttable presumption? When they tow your car without the jury actually determining that they're allowed to tow your car. Every time they tow a car, before you've went to court over the issue, before the jury has decided over the issue, before you've had an opportunity to be heard by the lawful judgment of your peers, That's a statute mandating an irrebuttable presumption. Why? Because they're not allowed to take your life, liberty, or property without due process of law. So the cop is ignorant. We're ignorant. The cop believes that he just has to do what he's told. He don't know the law. He don't know he's not supposed to be calling people to have people's cars towed. He just does what he's told. He's a good little boy. Right? So they said, yada, yada, yada. Irrebuttable presumptions have long been disfavored under the Due Process Clause of the Fifth Amendment. They said Connecticut was creating a statute mandating an irrebuttable presumption. They said it is forbidden by the Due Process Clause to deny an individual on the basis of a permanent and irrebuttable presumption, when that presumption is not necessarily or universally true in fact. They say you've never been given permission to do this. Who told you could do this? Let's see. They said this is another case. This is the United States Supreme Court. They said the question is whether a presumption has the quality of evidence. They said it doesn't. A presumption is not evidence. So what does that mean? That means they write a statute presuming something. The cop believes it's true, and he behaves as though because the statute exists, that's the evidence. Oh, you violated a statute. Yeah, but the statute can't take away rights. So I'm allowed to ignore a statute that would take away my life, liberty, and property and doesn't create an injured party. You see how fun this is? Say they disregard it every day. They tow cars like it's happy hour at the bar. Yeah. They said the question is this presumption evidence against somebody that you can take their stuff? No, it's not. That's what they said. This is all presumption. Whenever you hear a scammer on the internet talking and all these people, they're all speaking presumptions. They're not speaking facts. They're not speaking the law. They're definitely not speaking evidence that is admissible in court. You can't admit a statute into court to testify against somebody. A statute can't be injured. You know how crazy that sounds? Oh, you violated a statute. Well, a statute is an inanimate object. Did it complain against me? Okay, well, a statute can't say, oh, he hurt me. Okay, a statute does not exist. I'm gonna get in trouble. Let me stop. Did the statute tell you that? You know how crazy that sounds? Oh, he broke the law. But the law didn't accuse me. You accused me, and you don't have any alleged evidence of an injury. You know that's in the Magna Carta. They said that no sheriff, bailiff, constable is allowed to bring people that they're supposed to protect into court. See, that's what happens when we lose our history. We lose our way. They said the courts have never treated a presumption as any form of evidence. Say presumption is not evidence. Say a statute is not evidence. Let's see here. We talked about this earlier. I feel like I just read this, but I'm going to read it again. A statute is just a description of a violation. It's not evidence. There is no violation. A statute can't be violated. A statute can't be violated. Nobody can put their hands on a statute and the statute go call the police on you. That's not how a statute is not real. They said due process of law conveys the same meaning as the words by law of the land in the Magna Carta. This is the United States Supreme Court. They said that constitutions which have been adopted by the several states before the formation of the federal constitution. They said, but by the judgment of his peers or the law of the land. They said this is from the ordinance. This is what is conveyed in the ordinance of the territory of the United States of the Northwest Ohio River. And they say they use the same words. I can't read that. I don't need to read that. Here we go. Let's go to the Supreme Court of Georgia. The Supreme Court of Georgia said that it is a fund, but they apply it diligently. Well, that's because we let them get away with it. They get away. They get to do anything they want, because we're ignorant. That don't make it lawful because they do it. They tow people's cars every day. They've got no law that authorizes them to tow a car before somebody has been before a jury over the issue. They have no law. They can't prove any citation or anything that allows them to do it and it be constitutional. A statute cannot be violated. A statute is not real. The only thing that is constituting a violation is against persons, which on our side means a man or woman, or property, which can be damaged. You can damage somebody's property. So if there's no injured party, this magical statute does not exist. There's no such thing as a statute. There's no, it's literally, I can just say this is a it's just words on paper. It doesn't mean anything. It can't be hurt. It can't be violated. That's like saying a pizza can be hurt. It can't be hurt. It's not real. Oh, but they wrote it down. Okay, I could write anything down. What I write down can't be hurt. It can't be violated. That's a physical term. The Supreme Court of Georgia said it is a fundamental principle that no person shall be deprived of life, liberty, or property without due process of law. They said the government through the agency seeks to deprive a citizen of his liberty without authority of law. They said the prosecuting officer is bound to allege such facts established by evidence. They said prescribed by the law of the land. And they couldn't do it because a statute is not evidence of injury. What is the purpose of the courts? They're supposed to be redress for offenses against persons or property. Okay, well, a statute can't testify in court. It wasn't there. It doesn't exist. It's a non-inanimate object. It is an inanimate object. It's not non. Due process. Due process. Who is this? This is... Oh, here we go. They're telling us a story. The United States Supreme Court tells us what happened in England in the year 1215. They said at the point of a sword, the concession that neither lives nor their property should be disposed of except as provided by the law of the land. They said they meant by law of the land the ancient and customary laws of the English people. What happened? In the year 1215, I tell y'all this all the time. I got videos on YouTube about it. At 1066, William the Conqueror took over England. William the Conqueror came from Normandy. He was under French influence, Roman control. And as a result, there was a regime change in England. Okay, so this is where they introduced fake paperwork and corporations and all that other stuff. So by the time they get to the year 1215, the current king of England, John Lackland, begins, well, they've been doing it since 1066, but you get to 1215 and they're continually at an aggressive measure take away people's life and their property without due process of law, without the law of the land, without the law of the ancient English people. And so the people squad up, they confront King John at the point of a sword, and they say, hey, you're going to sign this and you're going to enforce it, or we're going to bang it out right here. You got an army with you. We brought an army with us. So this is very simple. You sign it or we get the banging it out. And he signed it. And so that's how they got the Magna Carta, where they were able to put the ancient English principles on a fake commercial document so that the corporation could uphold their end of the deal. Because remember, they have been invaded. They're under a new regime change. So they wanted their ancient English principles carried on and enforced against the government. They say, no, you can't take away people's life and property. The sheriff can't just be dragging people into commercial courts where there's no injured party. All of this stuff is in the Magna Carta. They said you can't be taxing people without their consent. They said all of this is embodied in the Fifth Amendment. So they said, the Supreme Court said, at the point of the sword in England, they said when the great barons of England wrung from King John at the point of a sword the concession that neither their lives nor their property should be disposed of except as provided by the law of the land that existed before King John got there, before William the Conqueror got there. And they meant by law of the land the ancient and customary laws of the English people, not the Normandy regime. So they say this is another Supreme Court case. They say law in its regular course of administration is due process. Excuse me. They said that due process is so secured by laws operating on all, not subjecting the individual to the arbitrary exercise of the powers of government unrestrained. They do it every day. Who is this? This is the Supreme Court of Florida, I think. So they said that the due process clause has its origin in the Magna Carta. Somebody say Magna Carta. They said that the Magna Carta due process exists every day. Due process exists every day for those who know the ancient and customary laws of the English people. They said the due process clause has its origins in the Magna Carta, that no free man shall be taken or imprisoned or be diocesed of his freehold or liberties or free customs or be outlawed or be exiled or in any otherwise destroyed, nor will we not pass upon him or condemn him, but by the lawful judgment of his peers. Say trial by jury. They said the court has recognized that at the time of the Fifth Amendment's ratification, the words due process of law were understood to convey the same meaning as the words by the law of the land in the Magna Carta. Due process, shall I read this? This is an old Virginia case, which they actually don't have on the internet anymore. Let me see if I can read it. Yeah, well, I can't read all of it because it's in Old English, but essentially they were saying the little cliff notes they got was that land was not liable for forfeiture for non-payment of taxes. This is the Supreme Court of Virginia. So yeah, of course they don't have it. They don't have it on the internet anymore. They have it, but you have to find the actual book of reports that has it. And they said in this case, they argued the Magna Carta that lands were not liable for forfeiture for the non-payment of taxes. They said the act of yada, yada, yada was copied from the Magna Carta to declare that no free man shall be deprived of his freehold, but by the lawful judgment of his peers or by the laws of the land, and that all have the benefit of a trial by jury. They said a further reason in support of this opinion arises from the principle of moral justice recognized by Magna Carta in England and by our very own Commonwealth, whereby it is declared that no citizen shall be disseised of his freehold or condemned by the lawful judgment of his peers. They say you're not supposed to be taking people's property without first being heard in your own defense. So that was the Supreme Court of Virginia. Let me see, who is this? Oh, no, that's not. Here we go. The Supreme Court of Minnesota, one of my favorite cases. The Supreme Court of Minnesota said that what is due process of law? Why they keep yapping about this stuff? What is it? They said due process of law renders judgment after trial. Say judgment after trial. Judgment after trial. They said, what is due process of law? They said due process of law renders judgment only after trial. They said in judicial proceedings, due process of law requires notice, hearing, and judgment. Notice, hearing, and then judgment. They said these words do not mean anything that the legislator may seem fit to declare due process of law. I heard an attorney tell me that point blank to my face. He said, oh, well, the legislator determines or defines what a crime. Nope. Crime's already been defined. Nope, you can't do that. You've never been authorized to do that. You can't show me anywhere in the Constitution where you've been given permission to define things. No, you were told what to do based on definitions that already existed. They said these words, due process of law, does not mean anything that the legislator may see fit to declare as due process of law. They said there are certain fundamental rights which our system of jurisprudence, Minnesota's, has always recognized, which not even the legislator can disregard. In proceedings by which a person is deprived of life, liberty, or property, and one of these is notice before judgment. So they have to give lawful notice of the thing they're trying to enforce, and then they have to have a judgment before they do the punishment. See, they start with the punishment. Oh, we'll tow that. We'll take this. We'll freeze the account. And that's not the law. They don't have no law that authorizes them to do that. Why? Because the United States Supreme Court says they restrain the legislator by the Magna Carta, by the common law of England, by the ancient principles of the English people. This is a book on the law book on the constitutional law. They said it is clear that the common law is the foundation of that which is the designated due process of law. They said when first adopted in the Magna Carta, the phrase law of the land had reference to the common law then existing in England. What do they mean then existing in England? In the year 1215. They say anytime you hear that phrase, due process of law, you got to go back to the year 1215. And honestly, you got to go back before then. They just put it on there. That ain't where it started. They said when first adopted in the Magna Carta, that phrase had reference to the common law then existing in England. And they said when embodied in constitutions in this country, they said there's more than one. They said your state's got a constitution. And then if you end up in federal situations, then you have a federal constitution. And they said when embodied in constitutions in this country, it referred to the same common law as previously modified. And then they cite the Supreme Court of Wisconsin, the Supreme Court of Vermont, the Supreme Court of Tennessee, and then some federal Supreme Court cases. Say due process is important. Let's see. Supreme Court of Wisconsin. This might be the case. Yeah. They said due process of, this is the Supreme Court of Wisconsin. They said that due process of law covers every right to which a member of the body politic is entitled under law. They said the limbs are equally protected with the life. The right to the pursuit of happiness in any legitimate calling or occupation is as much guaranteed as the right to go at large and move about from place to place. They said the word liberty implies the opposite of all those things, which besides the deprivation of life and property. These things, which is the opposite of liberty, were prohibited by the Great Charter. They said none of our liberties are to be taken away except in accordance with established principles. And they said nothing can be forfeited except on finding a legal cause after the hearing. They violate that every day, don't they? Who is this? Did my... Oh, I thought my mouse died. Who is this? This is the Supreme Court of Wisconsin again. They said an arrest without a warrant has never been lawful, except when public security requires it. That's called a breach of the peace. They said an officer is not permitted to arrest without a warrant for any misdemeanor. How many misdemeanors? They said it again. Oh, this is another case. They said at common law, arrests were not permissible without a warrant, except for acts committed in the presence of the officer causing a breach of the peace. And they said at the end of this citation that the legislator of this state has not modified the common law. They can't. That's why it's still in every state constitution. I looked at it yesterday. Some dude tried to debate me on South Carolina. He was like, no, you just don't understand. I said, the thing I cited from the Magna Carta is in South Carolina's constitution right now in 2026. He's like, no, but South Carolina's constitution is based off the United States Constitution. I said, no, the United States Constitution is based off of South Carolina's Constitution. South Carolina existed independently of this thing called a federal government 13 years before there was such thing as a federal United States Constitution. That United States Constitution is based off of the 13 states' constitutions. Each of them have their own constitution. You have your own state constitution right now, which the federal constitution is based off of. That wasn't the first time they had a constitution. In 1776, all 13 states had constitutions. And then in 1787, they created another one for the federal government. Supreme Court of Wisconsin again. Them boys nasty up there. Anybody from Wisconsin on here? The Supreme Court of Wisconsin said due process of law does not mean the will of the legislator. It don't mean they get to write whatever they want and call it law and call it due process. It means they get to take away your rights before you've ended up before a jury. They said due process does not mean the will of the legislator. Oh, that we followed due process because it's in the statute. No, a statute is not real. A statute can't be violated. Somebody say that. A statute cannot be violated. Violation is a physical term. A statute is an inanimate object. It does not exist. That's like saying a pizza can be robbed. A pizza can't be injured. The Supreme Court of Wisconsin said due process of law does not mean the will of the legislator. It means according to the law of the land, including the Constitution with its guarantees and the legislative enactments and rules duly made by its authority, so far as they are consistent with constitutional limitations. They do not have magical, unlimited authority to just be writing stuff and presupposing to take away people's personal property or their rights or their life. They do it every day, but I'm just saying they're not supposed to. I'm not naive. I know they don't obey this stuff. But they get away with it because we are the ones who are supposed to be enforcing it. Let's see. Does this make sense? Anybody getting this? Am I talking to a bunch of bots? They said there cannot exist under the American flag any governmental authority untrammeled by the requirements of due process as guaranteed by the Constitution. And people, scammers, all these people on the internet is just nobody should be against this. Everybody should be like, yeah, they're not allowed to take away people's stuff without having a trial first. Judgment or punishment is supposed to come after the trial. Right? But why don't they care? They don't care because they keep getting away with it. How do they keep getting away with it? We don't know the law and we don't explain the law to people, to our communities, our towns, our families. Here we go. I found this today. Who is this? This is from a law book on the due process of law. They said the doctrine that whatever parliament, so they're talking about England at the year 1776. They said the doctrine that whatever Parliament declares is the law of the land continued to be the center of attack up until 1776. So they said in England at the time of the Revolutionary War, Parliament thought they could do whatever they want to disregard people's rights. They said they just wrote whatever and they presumed whatever, and that this was the reason that they got to it, that they strapped up and got to it. They said they cited this from some dude who wrote a letter to somebody, and they said they were criticizing William Blackstone because William Blackstone said that that they confirmed by the passing of the Quebec Act, and they said that liberty in England meant one thing, but liberty in North America meant something different. So they said in the colonies and all the places outside of England, they're not entitled to due process of law. The legislator gets to write whatever for them. And they criticized him for that. They said, whoever this guy is writing this letter says that out of a free government, with a limited monarchy is now setting up governments that are not free with unlimited monarchy, which is not only to the subversion of the laws of the land, but by the establishment instead of a toleration of popery and the suppression of Protestantism and the religion of the Church of England. He said, you set up, which I've went over this before, you go over the Quebec Act, or it's called the Quebec Act of 1774, and they tell you the Roman Catholic Church took over Quebec because they took over the legislature in England. And through them being able to write whatever they want in England, then they were able to allow the Roman Catholic religion, which was not the Church of England, to have reign in Quebec. And they say it in the Declaration of Independence. They say, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, and enlarging its boundaries as so to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. They said they done took over Canada, or they done took over Quebec, which is in Canada, which is now known as Canada, and they're headed into the colonies. And so they said, well, boys, it's time to strap up. Why? What's the origin of the separation of church and state? The church was the Roman Catholic Church. That's the thing they did not want in the state, where they get to enforce ecclesiastical laws through equity and citations, which is what they did in Quebec. They literally took over Quebec. And they said, if we don't do something, they're going to do it here. They already doing here, but you know what I mean? And so they put it in the Declaration of Independence in the neighboring province. What was the neighboring province? Quebec. They said they got rid of that common. Yeah, we don't do that. How many times y'all done heard, oh, we don't do that common law stuff here? Yeah, that was in Old Britain. Yeah, because that's who they the ones they talking about in there. Yeah, y'all the ones in the Declaration of Independence they talking about. So yeah, the Supreme Court of Wisconsin said due process of law does not mean the will of the legislator. Let's see here. Yeah, they won't let me talk on YouTube. They said no audio again. Let's see here. So the courts of New York said by the law of the land, or due process of law, means the very act of legislation which deprives the citizen of his rights, privileges, property, leads to simple absurdity. So they said to think that whatever the legislator would write is due process of law is absurdity. They say it's crazy to think that they can just write whatever to take away people's rights, liberty, and property, or to believe that they can write anything that takes away life, liberty, or property.